Companies Act, a special presentation by The Firm.
Hello and welcome to Companies Act. Last week, we discussed the new responsibilities and liabilities of independent directors. This week, we continue our analysis of chapters 11 and 12 by focusing on board committees, intercorporate loans and investments, and related party transactions. The 2013 Act introduces for the first time a stakeholders relationship committee for all companies with more than 1,000 shareholders, debenture holders or deposit holders. It also for the first time makes mandatory the constitution of a nomination and remuneration committee for all listed companies and for public companies with a paid-up capital of 100 crore rupees or more, or a turnover of 100 crore rupees or more, or 50 crore rupees or more in outstanding debt. A nomination and remuneration committee must constitute 3 or more non-executive directors, of which at least half should be independent. Its job is to identify talent for senior management and directorial positions and evaluate director performance, as well as set remuneration policies for key managerial personnel and directors. Compared to the 1956 Act, the 2013 Act mandates audit committees for a smaller universe of companies. But while the 1956 Act made no reference to independent directors, the 2013 Act says an audit committee must have a minimum 3 directors, with independent directors in majority. Most of them, including the chairperson, should be able to understand financial statements. The responsibilities of an audit committee now include to recommend auditor, review and monitor auditor independence, examine financial statements, approve related party transactions, evaluate internal financial controls, and monitor the end use of public funds raised.
The major issue is not the composition of the committee, but the charter of the audit committee. Because now the responsibilities which is cast on the audit committee for the first time, they are made responsible to approve all related party transactions completely.
Yes. Yeah.
It's not the approval of the board. If only they come to a view that it's not in the ordinary course of business and it's not at arm's length pricing, then only it goes to the board and then to the shareholders. But audit committee having primary responsibility, some of the audit committee members have told that, Bharat, I don't know, if you look at all my responsibilities, my role, which was essentially an independent director's role of exercising supervision, seemed to have become more of an operating role. Because if you see the kind of duties which have been entrusted to them under section 177(4), and if you read it with the SEBI clause 49, it makes it so onerous in terms of the day-to-day. I don't know, I'm still able to figure out how it will work in practice if it is a prior approval.
No, I think it's a fact that lots of time will have to be spent by audit committees on many of these issues which have been listed. Their duties have
That's a
increased.
good thing, isn't it, sir? They're the
But
first
not for 20,000 rupees, so that
screening
fees have to
process,
go
aren't
up.
they, sir?
Sorry?
They're the first screening process for a lot of important financial situations. So isn't it a good thing that they
No,
might
I agree
spend more
with you,
time?
but ultimately you must also understand that independent directors join a company and they also join a management. So ultimately what we are saying is there has to be some trust and faith in the management also. No?
There are 2 other concerns. The audit committee should never have an executive role because it must maintain objectivity.
But it's not.
That's what
You
I
see
think
the
whole
words,
day
the
committee
words
members
used
have
here.
told me this.
I agree
Review
with you,
and
they will have to
monitor.
sit in the offices for
Review
number of
and
days.
monitor the auditor's independence and performance. Examine
okay.
the financial statement.
No, on related
Scrutiny
party.
of intercorporate
On
loans.
related
Yeah.
party,
Even
I'm
related
saying.
parties, it says approval.
Approve.
Yeah.
Approve.
It's not the question of reviewing,
One
it's
minute.
Of
approving.
transactions.
Primary
See,
responsibility.
what is the concern? Now, the promoter directors are no longer involved with the approval. In fact, they are the people who might well have instigated an improper transaction and they will now be scot-free because they'll say, we never were party to this whole thing. Nobody asked us.
Menika, the point which I think is canvassing, if a
the
proposal
board.
comes to the audit committee, and the management would just make a bland statement that in our opinion it's a transaction in the ordinary course of business and arm's length. Now what should audit committee do? How do they go about evaluating?
I don't agree with that. I think audit committee is probably the right place for it to be seen because they will probably have that specialist knowledge and the financial literacy to ask more detailed questions. I agree with Bharat that it has increased the workload of
Why not in the board where everybody then is responsible
because time
for
is
that
a constraint.
transaction?
Right, eventually
The
go to
audit committee has much more work than the board. So the board can.
But they are more expert as a body to.
But even then, they will depend on super experts
But
in
this
terms of
is what
external
it is.
advisors now.
This
It's
is
just
what
a-
it is.
But then, Menaka, if this is what it is, we should not discuss, no?
No, we are discussing impact, sir. We can't do anything else but
Impact means
discuss
a
the
lot of
impact
money
this.
for
Because
transfer
this is what it
pricing
is.
experts who will be asked to give opinions to justify
Because
the price.
that's what audit committees will rely on.
Yeah.
All the external
So this is all-
consultants
this
and
is
say,
all what's
please give
gonna
me
happen. This is what's gonna happen.
I
an
think it's made
opinion
the
on all of
process
this.
more cumbersome, and therefore there will be one sort of bundle of transactions which will probably not make it through this and then will stay out.
No, but I think, Menaka, we can't say that this is what it is, because there are representations.
lobbying for an amendment act,
No,
aren't you,
one
no?
minute. There are representations which have been made, and what we find now is that many of the things which should be in the act, through rules, they are changing and amending.
We'll get
some
to
of
that
the things.
yet. We'll
so
get to that
there is a
yet.
hope that some of these things
Well,
probably
the other risk is-
will be heard.
Also listed under Section 177 is the need for every listed company and a company which accepts public deposits or has loans of 50 crore rupees or more to establish a vigil mechanism with adequate safeguards against the victimization of whistleblowers. This also must be overseen by the Audit Committee. There are several other new provisions in the Companies Act 2013. It restricts a director from acquiring or selling assets to the company for a non-cash consideration without shareholder approval. It prohibits directors and key managerial personnel from forward dealings in securities of the company. And it also, rather unusually, covers unlisted companies in its insider trading prohibition. Though call and put contracts are not supposed to have specified prices under the new RBI SEBI requirements, could this end up hurting call and put contracts? Would that be your legal opinion?
Yes, as far as KMPs are concerned.
As far as KMPs are concerned. Not for independent directors,
No,
etc.
no,
This
no,
is only
no.
for promoters, right?
That's right.
Okay. And insider trading, now these provisions or prohibitions apply not just to listed companies, but unlisted public companies as well.
I don't know how it will work, first of all.
Because who are you trying to protect in
Not
this
only
situation?
that, but where is the price? Unpublished price sensitive information in unlisted public company where there is no market price. Where is the question of how the mechanism will
I
work?
don't know. I couldn't
No,
understand
would,
why they've applied it to unlisted companies.
I would like to rely on a landmark judgment of the Supreme Court in 2006, that Mill Land matter, which went, Bombay Dyeing versus Bombay Environmental Action Group, where Supreme Court says that if you find new provisions, it leads to absurdity. You have to approach a commonsensical approach. That it applies to listed companies, because I don't
Or
know.
the common sense approach could be, what is the real purpose of insider trading is to ensure information symmetry between both parties and other sort of people in similar,
But
like
you
other
have to read
shareholders.
down. You have to read it
You'll
down.
come across this. There might be several unlisted companies in your group. While you're following all the requirements that you need to with regards to protecting information in the listed companies, you now need to duplicate those for some of the unlisted intermediate companies in your group as well.
Yeah, I'm not clear about this provision at all, because
So have you
it
sought
talks
any legal
about
counsel on
it
it,
talks
saying how
about
do you-
insider trading.
Right.
It should
And-
be read down.
Huh?
In my opinion, it should be read down to apply to publicly listed
Because
companies.
trading, I don't know how
think that
trading
will
is going to
because
happen
I don't
on
think
in
they will
unlisted
completely. It
companies.
will make a difference for strategic or private equity transactions
the holding
in
company
unlisted
level.
company. How will you do diligence? What information will you share? I think this is a practical transactional impact it will have on any company. Why holding
So,
company?
but how will it work legally is my question, right? You have X company, which is the holding company. It has, let's say,
Why
15
holding company could apply to
list-
any unlisted
Any other?
company.
Any unlisted
No, I
company,
only
but I'm
made the
saying if
reference
you're
of holding because I thought there is some relevance.
Yeah.
It can
No, but if you
apply
have
for
15
any
listed
investment in a-
subsidiaries and you are buying, let's say, somebody is investing, in the holding company, the management of the holding company is now further restricted in being able to talk about what any of its listed subsidiaries may be doing, not doing, any of that. Any of that could then amount to insider trading.
But that
Menika,
is
this act has raised a very peculiar situation. Large number of concepts which are either to essentially governed by SEBI Clause 49 have been brought as part of the Companies Act and SEBI regulations. There are separate punishments prescribed under both the acts. Securities law, there is separate punishment. Companies Act, there is separate
This is
punishment.
Mr. Mirza's question.
Yeah,
right?
and the larger question is Constitution under Article 23 gives a categorical guarantee that there cannot be double jeopardy for a person for the same offence.
So which act?
Bharat,
Mr. Mirza's
constitutionally-
question was which
Bharat, that would be
punishment
for
would
listed.
apply?
And again, I will go
Companies
back to
Act
my original-
punishment or SEBI
My
punishment?
original that if there is a
Who will prosecute?
yes.
No, both prosecuted theoretically.
So who will punish
But
but?
then is
I
there no
think from a
double
listed
jeopardy
company it
protection?
will be SEBI. For an unlisted company it would be the. I think that is their understanding as well.
Companies Act, a special presentation by The Firm.
Time Time now for the toughest sections in Chapter 12, Sections 185, 186 and 188. Section 185 says, no company can give a loan, guarantee or security directly or indirectly to its director or to any other person in whom the director is interested. Now, the Act defines any other person in whom the director is interested to also include any body corporate, the board of directors, managing director or manager whereof is accustomed to act in accordance with the directions or instructions of the board or of any director or directors of the lending company. Now, this effectively blocks the ability of a holding company to extend loans, securities or guarantees to its subsidiaries, an activity that was exempted under the earlier law. The anomaly has now been corrected via the rules, but only partially. So loans, guarantees or securities to a wholly owned subsidiary or guarantees or securities to a subsidiary are exempt, as long as they're used by the subsidiary for its principal business activities. Section 186 poses a similar problem. It too places restrictions on loans, guarantees or securities provided by a company. If a company wants to extend loans, guarantees or securities exceeding 60% of its net worth or 100% of the aggregate of its free reserves and securities premium account to any body corporate, it needs approval via a special resolution. The threshold and the approval also apply to acquiring securities of another body corporate. The 1956 Act exempted loans, guarantees or securities to a wholly owned subsidiary from such threshold limits. The 2013 Act now seeks to do the same via the rules. So the special resolution requirement has been relaxed in the case of wholly owned subsidiaries and joint ventures. But that's only partial relief, as such loans, guarantees or securities will still be counted towards the threshold limits.
The major problem here which was there, that holding subsidiary exemption which was taken out in the Act, they were reintroduced to the rules. Otherwise it would have been a big chaos. If the exemption given from loans, investment and guarantees by holding company to its wholly owned subsidiary.
I think that's a very important point.
But they have introduced one more. In fact, not only they have introduced the exemption for wholly owned subsidiaries, they also introduced the exemption for joint ventures, which was not there in the 56 Act.
Are you happy with the way the rules have rectified what 185 and 186
so long as the rules, I mean, nobody challenges and there is no reversal, is fine.
I like your so long, sir.
So long. Because I don't know. The second part of the question, the lawyer should answer.
Yeah, it should have been done through using power under section 462, that is power to exempt.
Correct.
They could not have done, because power to exempt, you know, they have put a restriction that they can issue an exemption notification only after 30 days it was laid before the table of both the houses of parliament. Today we don't have a Lok Sabha. So they could not have done it, so they've used the rule route. In my opinion, it's an incorrect way of doing the thing. So statute, after a lot of debate in the Parliamentary Standing Committee, took out this exemption. They reintroduced the exemption through the rules. Corporates are happy, but I don't know how long
That's why I say so long.
How long the happiness will last.
I get it.
Or Bharat under 470, because they have taken a power to remove any difficulty.
But that, so long as it's not inconsistent with the Act, even that is also carved out. So
I don't think it's a complete fix what they've done under the rules, because it's only wholly owned subsidiaries that has been
But it's
exempted.
joint ventures as well, right?
But joint venture is not defined. Suppose you have only 20% equity in a joint venture, still it's carved out.
You can
And
have a
joint
company
venture
which is not a wholly owned subsidiary and not a joint venture and still have this problem.
In fact, you have created a very big loophole through
Which
a
is-
joint
there's a lot
venture
of
rule.
that.
If you ask me, people will you can just have a 10, so joint venture is not defined. You can have a 5% investment and still it is your joint venture, and you can give the loans and investments and guarantees.
So I don't think it's being completely plugged. So the absurdity.
Joint venture
No,
is under
so-
the accounting standards, is it? The definition of
How
joint
do you-
venture.
what is a
That is
joint
fair.
venture?
No, there's nothing. There is a definition.
no
under the
definition.
FDI policy, which is 3% investment.
So you could pretty much give a loan or a guarantee or a security to anybody.
Any company which
and
you have
claim
more
that
than
they're a joint
3%, then
venture.
you can. It's a joint venture, and you
No,
are
I
out.
think you need to meet a slightly higher qualitative test. You can't just say a
No, let's
passive
assume you
3%.
need to. Are you worried about the fact that the rules are attempting to fix what the Act has,
So
has attempted to
there's an issue
disallow?
of terms of overreach by the rules. That's a legal issue. Until that rules are struck down or somebody challenges it, it's
Yeah.
useful to have. So leave that aside for a second. But even if you take the rules as they stand today, it does not fix the essential problem that 185 was posing, which is the overreach in terms of applying it to companies within the group, your subsidiaries and affiliate companies in the group, simply which became affiliated because of common directorships. They have alleviated the problem only as far as wholly owned subsidiary is concerned. The joint venture exception has got very limited use. I think you still have a problem. And we're actually seeing this in terms of companies which are wanting to make this kind of facilities. Bankers are worried about it because they have doubts on whether the parent support that they're getting in relation to loans to the subsidiaries.
I think
no. The problem is, why are lenders uncomfortable with this? So lenders are the recipients of guarantees or parent supports that are given, and when they receive that kind of support, they want to know that it is lawful and in compliance with Section 185. They are taking this just now on a tenuous basis with all this ambiguity that is involved. So that is why lenders are unhappy.
I get it. Okay.
Manika, to only clarify one thing, in the definition of an associate company, which is 20% or more, they have said includes joint ventures, implying therefore that even a 20% holding would make it a joint venture.
So
What they should have saying the 3%, but here in the Companies Act there's a definition.
I'm stretching it to an absurdity to
what they should have done
is
applied it to all subsidiaries, not necessarily restricting it to wholly owned subsidiaries.
Okay, which brings us to one final point, which is related party transactions. The rules to the 2013 Act require extensive disclosures for all related party transactions, including particulars of contract, pricing and commercial terms, including those outside the contract. Barring those related party transactions entered into by a company in its ordinary course of business and at arm's length, all other related party transactions pertaining to the sale or purchase of goods, materials, property, services, agency services and the like need board approval. All related party transactions not in the ordinary course of business or at arm's length require special resolution approval in the case of a company with a paid-up share capital of 10 crore rupees or more, and in the case of other companies, for all transactions that exceed prescribed limits. For the first time in Indian company law, a shareholder who is a related party cannot vote on the special resolution.
Effectively, as you read today, if you read the plain reading of the language, if the company has a paid-up capital of more than rupees 10 crores, the entire regulatory regime applies to you, irrespective of the fact that the transaction thresholds are not met.
Which means that you need audit committee pre-approval, board approval, special resolution approval from shareholders, and in the case of any interested shareholder, that shareholder is barred from voting.
But the only thing is that if it is not in ordinary course of business.
And not at arm's length. Not at arm's length.
Those two things are important.
But only
only
the
for
Companies Act is
exceptional
not giving any guidance on how do you determine pricing, how do you determine the pricing, unlike Income Tax Act where there is a specific method.
So I think you need to have some policies approved by the board on some of these issues, and independent directors will have to approve those policies.
That's
also.
right.
Okay, there's one more interesting thing which we've touched upon briefly here, which is that the interested shareholder cannot vote when a special resolution approval is being sought, which effectively means wherever a promoter is involved in a related party transaction.
No related party can vote.
No related, so any interested
not
party.
Not just
right,
the party who is interested in the transaction.
The party which is related for that transaction.
No, it's
only
not. It's not.
No,
it's
the
not
wording
clear.
is
He's right, the language is
but
not
if you
clear.
see the language, it's very clear that that related party, it's not referred to, there are three related parties, but only one is interested in the transaction.
So based on a conflict of interest principle.
Yes, conflict of interest.
It should be. I agree.
It should be, but Mr. Mirza is right.
But
it doesn't say that that particular related party should not vote. It says the related party should not
but
vote.
But the larger problem which people have not touched upon, and that is the issue with regard to who is a related party. And one category which is in the definition of related party, that is 2 subsection 76 subclause 5, which if there are one common director between two public companies, that also makes the two public companies related parties. So if there is an independent director of company A and independent director of company B, it's a related party. There is also a word, or if he holds 2% capital, they are planning to issue removal of difficulties order, which is on the website of the ministry, but yet not notified or signed by the minister.
So Mr. Mirza, all the companies you're on the boards of, they're all related. But both are related now, sir.
Yeah, I know.
Both are related.
According to Bharat's
that's right.
This thing, clarification.
As of now.
I am waiting to see how general meetings of shareholders are going to approve these transactions. Because these are not simple, straightforward commercial things, and you've got housewives there who come in with plastic bags to carry away the
Why would you underestimate the ability of a housewife to determine?
Their ability to comprehend the issue before this.
Stereotypes.
It is a stereotype, I agree. But I don't know how this is going to get approved in...
Good, shareholders will grow up, become more mature, learn
in the packing order, I think the minority shareholders have become the new majority now.
Apart from the entire psyche of independent directors that has changed. I think another profound impact has happened on the psyche of promoter directors as well, to now deal with this whole concept of majority or minority. So it's no longer enough to say that I own 51% of this company or 75% of the company, so I can do what I want with it. You could find yourself, and promoters are coming to terms with this new reality, that on several important things they have no voice at all, and decision making in the company would be made by this minority, with them just standing on the sidelines watching how this performs. And I think from an ethical perspective, I think it's a good thing. From a practicality of doing business perspective, I think there is an overreach, simply because that this applies even in cases where there is no specific benefit. Even if the terms are pari passu and fair, even then you have to go through this rigor, and you don't know whether the minority has enough of a sort of a business judgment or assessment to take a proper call.
This also, according to me, in the long term, it's a good provision. However, it's a process. We need to have much more enlightened, knowledgeable shareholders to do this.
I have a slightly different problem with this, a more intellectual, conceptual one, which is, firstly, as an owner of property, namely the shares, I am entitled to act in self-interest. The rule for acting in a fiduciary responsibility applies to the board. You are effectively now applying fiduciary principles at the ownership level, and you are saying you shall not act in self-interest. That is number one. This could have been dealt with through a disclosure regime as well. You could have had disclosures, you could have principles in which you will sort of deal with as well. So why would a disclosure regime, a strong disclosure regime with the requirement of approval, but without conflicting me out from voting, not have been enough?
How has life for boards changed, Mr. Deosthalee?
Well, it's a process. According to me, boards will learn to live with this situation. Ultimately, with all these things, if the efficiency of the board improves, then I think that's a good thing to happen for the companies in India. But if it is going to result in something else in terms of looking over the shoulders continuously, then asking more and more and more questions just for satisfying the requirements of this act, I think then we would achieve nothing.
Mr. Shroff, how is life for boards changed?
I think it's all of the above. I think certainly boards have become far more active. The nature of the discourse has changed. Independent directors have found a sort of a new voice, and I think there are also a group that's developing on most boards of independent directors, seeing themselves as a sort of a power center by themselves, as Bharat was pointing out some time ago. So its life has become, there is certainly a milestone in terms of a new era of corporate governance. I can see that, and it really comes to roost on important decisions like, say, an M&A transaction or a capital raising or something which significantly changes the nature of the company. The level of discussion and the level of caution, sometimes even a little bit of paranoia, is significantly higher.
Certainly the act has created an architecture for better corporate governance. The only question which Mr. Deosthalee has raised, is the focus going to shift from business issues to more compliance issue? That is a worrying part.
Mr. Mirza?
Last month I was lecturing to a group of people who were aspiring independent directors.
There are still that kind left after this act, sir?
There are. And my message to them was that when you do receive an offer to be a director, don't think of all the reasons why you should accept the offer, but of all the reasons why you should refuse it.
Okay.
And only if you can, even in spite of that, convince yourself that it's an offer worth taking, only then should you take it.
Be very, very selective of
That's
the boards
essential.
you're going to join, of the managements you trust, and of the promoters you hobnob with.
Correct. Because the problem is that SEBI has opened the doors to all sorts of promoters who should never have been permitted to list. And having permitted them now, they make these rules and regulations, and the government does the same. The problem is there. You should never allow these people to take money from the public. Once you allow them, there's no matter how many barn doors you try to slam shut, the horse has bolted.
Next week on Companies Act, Accounts and Auditors.
Companies Act, a special presentation by The Firm.